In 2025, Amazon paid $2.5 billion. Not because they sold you something bad, because they made it too hard to leave. They built a cancellation process so complicated, they named it internally after an ancient Greek epic, because it never ended. That name came out in federal court documents, and a federal court said, that's illegal. Now here's what nobody's telling you. The same trap, the exact same clause, is sitting inside almost every paid digital free trial you've ever signed up for. And before this video is over, I'm going to show you exactly where that clause is hiding, what it can cost you, and the one move that changes everything, depending on where you live. Stay with me. Picture this. It's a Tuesday night. You're on your phone, killing time. You see an ad for some app. Maybe it's a design tool, maybe it's a fitness tracker, maybe it's a streaming service you've been curious about. And right there at the top, try free for 7 days. So you tap it. You put in your email, you put in your card number, just to verify, they say, and then you get busy. Work, kids, life. 7 days go by. And somewhere on a server you'll never see, a company you barely remember just charged your card. Not for a month, for a year. If that's never happened to you, you're either very lucky or you haven't checked your statements lately. Because here's the scale of this thing. A survey by C+R Research found that the average American thinks they spend $86 a month on subscriptions. The real number? $219 every single month. That's a $133 gap every month that most people have no idea exists. And 48% of Americans, nearly half, have forgotten to cancel a free trial before being automatically charged. Among millennials, that number climbs to 65%. This isn't about forgetting. This is about a system that was designed for you to forget. And that system has a legal name. And depending on your state, it may be completely, legally working against you right now. Let me show you exactly how. So, what exactly is a negative option? Here's the simplest definition I can give you. A negative option is a contract term that says, if you don't say no, we assume you said yes. Your silence, your inaction, your forgetting, all of it counts as legal consent to keep charging your card. Now you might be thinking, how is that even allowed? Great question. The honest answer is because the law that was supposed to stop it is 50 years old. In 1973, the year of Watergate, the year the last American combat troops left Vietnam, the Federal Trade Commission created a rule about negative options. But that rule was written for a very specific thing. Book of the Month clubs. You know the ones. You'd get a notice in the mail. If you didn't send back a card saying no thanks, they'd ship you the book and charge you for it. That was the whole rule. That was the scope of it. Fast forward to 2024. Now we have streaming services, SaaS subscriptions, fitness apps, meal kit deliveries, VPNs, password managers, AI tools, hundreds of billions of dollars flowing through digital free trials every single year. And the main federal rule covering all of it? Still technically based on that 1973 book club law. The FTC knew this was a problem. They spent years trying to fix it. In 2024, they finally passed a new rule, the Click-to-Cancel rule, that would have forced every company to make cancellation as easy as signing up. It was supposed to take effect in the spring of 2025. Then they delayed it to July 14th, 2025. And 6 days before that deadline, a federal appeals court threw the whole thing out. Not because the protections were wrong, not because the court said companies should be allowed to trap you, because of a paperwork error, a procedural technicality. The FTC hadn't filed a specific type of economic analysis that federal law requires when a rule costs more than $100 million to implement. And just like that, the most significant consumer protection for subscriptions in 50 years, gone. And what that means for you depends almost entirely on your zip code. So the big federal rule is gone. What's left? The answer is, it depends on where you live. And I mean that literally. Right now, across the United States, there are two completely different realities for consumers dealing with subscription traps. In some states, California, New York, Minnesota, Colorado, Illinois, there are strong automatic renewal laws on the books. Laws that require companies to get your real consent before enrolling you. Laws that require notice before they charge you again. Laws that let you cancel the same way you signed up. In other states, Texas, Florida, Alabama, Wyoming, and more than a dozen others, there is no dedicated state law covering this at all. Zero. If a company buries the annual commitment in a hyperlink on page 3 of their terms of service and you didn't catch it, in those states, that contract is valid. That charge is legal. And then there's the middle. States with laws being written right now, or laws that just went into effect, where the courts haven't even decided yet what the rules mean in practice. Massachusetts, Pennsylvania, Arkansas, Maryland. If you live in one of those states, check your state's current law before you rely on it. Things are moving fast. But here's where it gets genuinely interesting. Because California, the state with the strictest law in the country, has a protection that almost nobody knows about. If a company enrolls you in an automatically renewing subscription without clearly disclosing the terms, if they didn't show you conspicuously that you were signing up for something that renews, then under California law, anything they sent you during that unauthorized renewal period is considered a gift. You don't owe them a cent. The goods are yours. The service was yours. They can't sue you for it. They can't send it to collections. Legally. A gift. Now, does that mean you should sign up for every trial in California and never cancel? No, that's not legal advice, and the specifics matter a lot. But what it does mean is this. The same company running the exact same free trial trap faces completely different consequences depending on which state their customer lives in. And they know it, which is exactly why the cases you're about to see are so important. Hey, real quick. You just saw how a federal rule that was supposed to protect you got thrown out 6 days before it took effect. And you're about to see the companies that paid billions of dollars because they got caught doing exactly what I described. If you don't want to miss that, and the part at the end where I show you what you can actually do about this today, hit subscribe on Law Drop right now. Hit the like button on this video. It helps more people find this information. And tap the bell so you don't miss what's coming next. Because this is just one of dozens of traps hiding inside contracts most Americans sign every single week. Let's get back into it. Let's talk about Adobe. You probably know them. Photoshop, Acrobat, Creative Cloud, a company worth tens of billions of dollars. And in June 2024, the Department of Justice and the FTC filed a federal lawsuit against them. Not against some shady startup, against Adobe and 2 of its executives, by name. Here's what they did. When you went to Adobe's website to subscribe, they pushed you toward their most popular plan, annual, paid monthly. It was pre-selected, already checked, the default. The monthly price was front and center, big, bold, easy to see. What was not easy to see? That you were signing a 1-year contract, and that if you tried to cancel before that year was up, after a 14-day window, you owed them an early termination fee equal to 50% of every payment remaining on that contract. That fee was buried, hidden in small print, behind a hyperlink, behind an icon you had to hover over with your mouse to even reveal. And when people called to cancel and were hit with a fee they never knew existed, Adobe's own cancellation process was designed to stop them. Multiple screens, multiple steps, calls that got dropped, transfers between representatives, people who thought they'd successfully canceled, still getting charged months later. Now here's the detail that the court documents revealed that I want you to really sit with. Adobe's own executives knew. An internal email, obtained by the FTC and included in the unredacted lawsuit, described the early termination fee as, and I'm quoting directly here, a bit like heroin for Adobe. That's what one of their own executives wrote. They knew the fee was something people didn't understand. They knew it was keeping people trapped, and they knew it was making them money. In March 2026, after nearly 2 years of litigation, Adobe agreed to pay $150 million to settle. $75 million in civil penalties, $75 million in free services to affected customers. But Adobe isn't even the biggest story here. Because in September 2025, the FTC announced a settlement that broke every record in the agency's history. $2.5 billion against Amazon. The allegation? Amazon had been using what regulators call dark patterns, deliberate design choices that trick you into doing something you didn't intend to do, to enroll millions of people in Prime subscriptions without their clear consent, sign up during checkout, add Prime accidentally on a single-page purchase, click the wrong button during a free trial. Amazon knew exactly how confusing the flow was. How do we know? Because a former Amazon UX researcher named Reed Nelson testified against them. He told the court that he had repeatedly flagged Amazon's design as misleading, that it was deliberately confusing, that Amazon's own internal data showed customers didn't understand what they were agreeing to. And in one exchange that made it into the trial record, it came out that Amazon's business goals, the revenue targets, would be, quote, very difficult to hit if the Prime sign-up process were more transparent. That's not an accident. That's a business model. And their cancellation process, the one they called Iliad internally after the ancient Greek epic, was built the same way. You had to reaffirm your desire to cancel 3 times before the cancellation would go through. The FTC said, that's not a cancellation process, that's an obstacle course. Amazon paid $2.5 billion. And if you had an Amazon Prime subscription between June 2019 and June 2025 and tried to cancel but couldn't, or signed up without fully realizing it, there is a claims process open right now through July 2026 where you may be eligible for a refund. Check your state laws and eligibility before filing, but that window is real, and most people don't know it exists. Now, Adobe and Amazon are the ones that got caught. They had the resources to fight federal lawsuits for years, and they still ended up paying billions. The companies that didn't get caught, they're still running the same playbook. Right now, in apps you probably have on your phone. So how does this actually work in practice? Let me show you the 5 specific tactics companies use to hide these terms. Because once you see them, you cannot unsee them. Tactic 1, the pre-checked box. You're signing up for something, moving fast, and somewhere on the page, usually below the main content in a smaller font, there's a checkbox, already checked. It says something like, I agree to the annual subscription terms, or I authorize automatic renewal. You didn't check it. You don't remember seeing it. But legally, in most states without strong auto-renewal laws, that checked box is your consent. Tactic 2, the buried hyperlink. You're on the final checkout screen. There's a sentence, one sentence, that says something like, by continuing, you agree to our terms of service. Terms of service is a link, blue text, easy to miss. You click it, if you click it, and you're now reading a 30-page document. Somewhere on page 4, paragraph 11, it says you're agreeing to annual billing and a 50% early termination fee. Nobody reads it. Companies know nobody reads it. That's the point. Tactic 3, the hover icon. This is what Adobe specifically did. Next to the price on the checkout page, there's a small circle with an eye, an information icon. If you hover your mouse over it, a tooltip appears with additional information about the contract terms. If you don't hover, if you're on a phone where hovering doesn't exist, you never see it. The FTC called this deliberately hiding material terms from consumers. Adobe called it disclosure. A federal court sided with the FTC. Tactic 4, the ETF ambush. This one is the most infuriating. You signed up for what you thought was a monthly subscription. Maybe you didn't notice it was annual. 30 days later, you decide it's not for you. You go to cancel, and that's when they tell you. That's the first time you see the early termination fee, not during sign-up, not in a confirmation email, not in any reminder. At the exact moment you're trying to leave. Adobe's own lawyers described this in court documents. They called the ETF a powerful retention tool, a tool for retention, not a fee, not a disclosure, a tool to keep you paying. Tactic 5, the save tactic maze. You've made it past the ETF shock. You still want to cancel. Now the company presents you with offers. Stay for 20% off. Get 2 months free. Are you sure? Here's what you'll lose. Screen after screen. In some states, California for example, companies are now required to show you a clear cancel button even while making these offers. You can skip straight to cancellation. In most other states, they can run you through as many screens as they want, and every extra screen, every extra click, every extra second, some percentage of people give up. That's the calculation. Here's the thing, none of these tactics are secret. They're not hidden in some backroom strategy document. Companies discuss these design choices openly in business conferences. They A/B test which version of the buried hyperlink gets fewer people to click through. They measure save rates, the percentage of people who started to cancel and didn't finish. This is the subscription industry. These are standard practices. And in most states, right now, most of them are legal. Okay, let's talk about your state specifically. Because everything I've shown you so far, the buried clauses, the pre-checked boxes, the ETF ambush, how much of that is actually illegal where you live? The answer is, it depends on which of 3 categories your state falls into. Category 1, strong protection states. These states have passed their own automatic renewal laws, and they mean it. California is the gold standard. Under California law, if a company didn't clearly and conspicuously disclose the renewal terms before you signed up, and I mean really clearly, not buried in a hover icon, then anything you receive during that unauthorized renewal period is legally considered a gift. You owe nothing. They cannot collect. And pre-checked boxes? Banned entirely. New York updated its law in May 2025. Companies now have to send you advance notice 15 to 45 days before renewing a longer contract. And if they want to raise your price after renewal, they have to get your consent first. No consent, no increase. Minnesota went even further as of January 2025. They banned save tactics, those screens that appear when you try to cancel, unless you specifically ask to see them. If you say you want to cancel, they have to let you cancel, period. Colorado now requires a true one-step online cancellation link. One click, done. No maze. Now, to be clear, having a strong state law doesn't mean companies always follow it. It means you have legal recourse if they don't. That's a very different thing from having nothing. Category 2, gray zone states. These are states where laws are either brand new, still being interpreted by courts, or in the middle of the legislative process right now. Massachusetts passed new auto renewal regulations through its Attorney General's office, effective September 2025. Among the strictest new requirements in the country, but courts are still figuring out how they apply in practice. Arkansas just passed its first automatic renewal law in August 2025, largely mirroring California's approach. Georgia has a law but applies it differently and extends some protections to small businesses rather than just consumers. If you're in one of these states, the law may be on your side, but check your state's current rules before you rely on them, because things are moving fast and not every court has weighed in yet. Category 3, minimal protection states. These states have no dedicated automatic renewal law. If you live in Texas, Florida, Alabama, Wyoming, or more than a dozen other states, your primary protection is ROSCA, the federal law from 2010. ROSCA requires clear disclosure, real consent, and a simple cancellation method for online subscriptions. It's real. The FTC enforces it. But ROSCA doesn't give you a private right of action, meaning you personally can't sue a company under ROSCA. Only the FTC can bring those cases. And with the click-to-cancel rule gone, you're relying on a federal agency to notice, investigate, and act on your specific situation. So what does this map actually mean for you? It means the same company, running the same free trial, hiding the same clause, plays by completely different rules depending on your zip code. A consumer in California has the right to call that renewal unauthorized and keep the goods. A consumer in Texas, with the exact same experience, may have no state-level recourse at all. Same trap, different state, completely different outcome. And that gap, that geographic lottery of consumer rights, is exactly what the companies count on. But here's what they definitely don't count on: you knowing your options. Okay, you've seen the trap, you've seen the cases, you've seen the map. Now, let's talk about what you can actually do. Because the companies count on you not knowing this part. Move 1. Before you sign up, read the commitment, not the price. When you see a free trial offer, the price is the first thing they show you. The commitment is what they hide. Before you enter your card, look for these 3 things specifically. Does this trial convert to a monthly plan or an annual plan? Is there an early termination fee if I cancel before the year ends? How do I cancel? And can I cancel online the same way I'm signing up? If the answers to any of those questions aren't visible on the page you're looking at right now, not behind a link, not in a tooltip, that's a red flag. In states like California and New York, that may actually be a legal violation. In other states, it's still a warning sign. Move 2. Use a virtual card number. This is the move most people have never heard of. Many banks and credit card companies, including Capital One, Citi, and privacy-focused services like Privacy.com, allow you to generate a virtual card number with a spending limit or an expiration date. You use that virtual number for the free trial. When the trial ends and the company tries to charge you the annual fee, the card is already canceled or over the limit. The charge fails. No cancellation maze, no ETF ambush, no save tactic screens. This doesn't work for every situation, and you should always check your bank's terms. But for digital subscriptions, it's one of the most effective tools available to consumers right now. Move 3. Document everything when you cancel. If you're trying to cancel a subscription and running into resistance, document the entire process. Screenshot every screen. Save confirmation emails. Write down the date, time, and name of every representative you speak to. If the company claims you never canceled, you have the receipts. And here's why this matters legally. Under ROSCA, companies are required to provide a simple cancellation mechanism. If they're making it deliberately difficult, multiple screens, dropped calls, transfers, that may be a violation of federal law, regardless of your state. Your documentation is what turns your complaint into a case. Move 4. File the complaint and file it in the right place. If you've been charged for something you didn't authorize, or if a company made cancellation unreasonably difficult, you have 2 places to report it. The FTC at reportfraud.ftc.gov. This feeds directly into the enforcement database that triggers investigations like the Amazon and Adobe cases. Your state attorney general's office, especially powerful in states like California, New York, and Minnesota, where the AG has dedicated consumer protection authority over auto renewals. These complaints matter. The FTC cited thousands of complaints from all 50 states as evidence of the scale of this problem when it built its case for the Click-to-Cancel rule. Your report isn't just for you. It's the data point that becomes the next billion-dollar enforcement action. Move 5. Dispute the charge with your card company. If a company charged you for something you didn't authorize, or charged you after you attempted to cancel, you have the right to dispute that charge with your credit or debit card company. Under the Fair Credit Billing Act, credit card companies are required to investigate unauthorized charges. Debit cards have some protections too, but they're generally weaker. Another reason to use a credit card, not a debit card, for free trials. When you dispute, say this clearly. I did not authorize this recurring charge, or I attempted to cancel and was unable to complete the cancellation process. Be specific, keep it factual, and submit your documentation. These 5 moves won't protect you from every subscription trap out there, but they will make you significantly harder to trap than the average person. And right now, before I show you the most disturbing detail in this entire story, I want you to understand just how deliberate all of this is. Okay, I told you at the beginning I was saving the most disturbing detail for last. Here it is. Adobe's internal email described the early termination fee as a bit like heroin. But that's not the part that should keep you up at night. The part that should keep you up at night is what came right after that. The executive who wrote that email wasn't fired, the practice wasn't stopped, the fee wasn't disclosed. For years after that email was written, years after someone inside Adobe put those words on paper, the company kept running the exact same enrollment flow, the same pre-selected annual plan, the same buried ETF, the same cancellation maze. Because it worked. That's the business calculation. According to the federal complaint, the cost of eventually getting caught, $150 million, was weighed against the revenue generated by millions of customers who never knew they were in a year-long contract. And on that math, for years, it was worth it. Now, there's one more thing I want you to know before you leave. If you had Amazon Prime between June 2019 and June 2025, and you tried to cancel but couldn't complete it, or signed up without fully realizing it through Amazon's checkout flow, the claims process is open right now, through July 2026. $1.5 billion set aside for eligible consumers. You can file at subscriptionmembershipsettlement.com. Check your eligibility, check your state's laws. This video is for informational purposes only and does not constitute legal advice. Always verify current requirements before filing anything. But that money exists, that deadline is real, and the companies were counting on most people never finding out. You found out. If this video helped you, send it to one person who needs it, not as a share, as a warning. Hit like, subscribe to Law Drop, and tap the bell. And drop trial in the comments if this ever happened to you. The next video is about your employer tracking your GPS location 24/7, on weekends, off the clock, when you're not even working. In most states, that's completely legal. That one's already up. I'll see you there.